When does legal get involved? Best practice from day one. Because when thinking about a divestiture, when thinking about all the strategic actions a company should take, there's a legal consequence to all of that. Whether you like it or not, lawyers have influence everything, and one needs to be cognizant of the legal ramifications of any action they take. And so, in my view, a best practice is to have the lawyer in the room when the strategy is being developed. A lawyer should be in the room when the business development team is entertaining different options, whether acquisition or divestiture.
Welcome to M&A Science, where leading M&A practitioners share lessons learned from their experience. If you're interested in keeping up with the latest from M&A Science, visit mascience.com and subscribe to our free newsletter. Every Monday, we share highlights from our interviews and invitations to events as we build the greatest community of forward-thinking M&A practitioners. Again, that's mascience.com. I'm your host, Kison Patel, CEO and founder of M&A Science. Joining me today is Andrew Gratz, Chief Privacy Officer and Associate General Counsel at LyondellBasell, one of the largest chemical companies in the world, trading on the New York Stock Exchange under LYB. Today, we're going to talk about the legal team's role during a divestiture. Andrew, how's it going?
It's going great. Thank you for having me.
My pleasure. Thanks for coming back. Can we kick off with a little bit about your background?
Sure. No, thank you. I have been practicing law for about close to 20 years, and most of that time I've been a deal lawyer, which basically means that I've been the primary lawyer for mergers, acquisitions, divestitures, joint ventures, and a variety of other strategic transactions. Some of that time it was in private practice, and some of that time was at LyondellBasell. And so I've had the opportunity to do deals all around the world, private deals, public deals, and I'm sure many of those lessons learned we'll discuss today.
Hey, thank you. Yeah, absolutely. Because you were there 13 years. So, and knowing what the company's done, been part of some really interesting transactions.
I've been very fortunate. A few weeks after I joined the company, LyondellBasell filed for bankruptcy. And to this day, it's one of the largest bankruptcies in US history. So I was able to work with my colleagues and the C-suite at the time to help navigate us through Chapter 11 and to emerge successfully. Subsequent to that, I've been able to provide legal support through a variety of transactions. And specifically in the last 5 years, I led the team that helped acquire A. Schulman, which was a publicly traded company out of Cleveland, Ohio. And most recently, in the past year, I was the lead attorney for our JV investment, where we acquired half of a site, petrochemical site from Sasol in Lake Charles, Louisiana. So I've been very fortunate in my career to be part of some amazing deals and frankly, work with some phenomenal teams.
Yeah, I love the diversity. And I guess speaking of that, from a legal perspective, how would you depict the main differences between an acquisition and divestiture?
Sure. The way I describe it is an acquisition, the work is really in the front end. Prior planning will, if done well, if done efficiently and effectively, will lead to a successful transaction. And so when dealing with a divestiture, you really have to get all your ducks in a row to ensure everything is designed, developed, and really more importantly, presented appropriately. Acquisition, a lot of the work is done on the back end. You're doing due diligence. You're looking at the deal. You're looking at the target you want to acquire. As the seller, when you're doing a divestiture, it requires a significant amount of work in the front end. Doing that correctly, doing that thoughtfully, will typically lead to a successful deal.
When we look at maybe can we walk through a carve out situation?
Yeah.
Right. Like where do you start and go from there?
So whether it's a carve out or selling a business, maybe it's helpful to discuss what's the first step. The first step that the team needs to understand, and absolutely the legal team needs to understand, is why are we doing this deal? Are we doing this deal because we need cash? Are we doing this deal because this business is no longer advances the overall company strategy? Are we doing this deal because this particular site has a lot of legacy liabilities that we want to shed? Are we doing this deal because, frankly, we want to go a different direction? If the entire deal team, and especially the legal team, if we don't understand the why, we can't develop the how. And so no one should be discussing divestitures or, frankly, any M&A until you understand the why. After that, how? Are you doing a carve out? And I'll get to your question in a minute.
All
Are
right.
you selling a legal entity? Are you doing a bilateral deal? Are you doing an auction process? How are you hoping to effectuate the divestiture? And once again, understanding the how will have a profound impact on all the work you have to do and all the steps you have to take to ensure a successful divestiture. Happy to go into all those steps or maybe address the carve out, whatever you prefer.
Yeah, I like how you start with defining the why, really the strategy of what's the drivers of doing this carve out, and then think of how you're going to do it.
Yeah,
Let's walk through those steps. I
absolutely.
really want to understand this because I get it from the corp dev side, but I think we know legal folks do a little bit more work.
Well, different work. Our the corp dev teams I've worked with are phenomenal. But here's where you do work with the corp dev team. First step, after the how and the why, is identifying what you're actually selling, and from a legal perspective, the issues that may arise based on what you're selling. So let me give you an example. If you're selling a legal entity with certain assets owned by that legal entity, there are going to be contractual issues. And in those contractual issues, there may be change of control, where the contract provides that if the legal entity attached to this contract is sold, the other party can terminate. Well, if the real value of the business you're trying to sell is attached to that contract, and you can't transfer that contract because of that change of control provision, how much is the business worth? That's a real issue. So the first thing the legal team will do is scrub all the contracts attached to the asset or business being sold to make sure there are no change of control issues. Second, employment issues. Well, do we want to keep some of those employees? Are we fine with those employees being transferred with the business we're trying to sell? And then how valuable are those employees to the operation of the business? Do we need to put retention agreements in place? Do we need to make sure that management team is working for us as the seller, or in their back of the mind, they're realizing that they're no longer going to be working with us in a year from now, so their loyalties lie elsewhere? Are they tied for a year or two to the asset in question because the buyer may not know how to run the asset? And so they will need those employees to at least run the asset or train their folks and bringing them up to speed. Well, if the employees can walk off the site as soon as the deal closes, what value does the asset have? You also look at tax issues. Never forget your friends in tax, because any deal may have tax consequences. And so you always want to clear your proposed transaction with your tax advisor to make sure there is no adverse consequences of going to an equity deal or an asset deal or some combination thereof. Your debt instruments. Well, if the business or asset you're looking to sell is collateralized, well, then your bank will have an interest if you're trying to sell that asset or business. So you need to scrub your debt instruments to make sure you have the ability to actually sell that asset or if you need your consent. Permits. If the permit is in your name, how will the acquirer get those permits? How will the acquirer have the ability to run those assets on day one? Licenses, same thing. If those assets are dependent on having certain licenses, and those licenses are in the seller's name and not the buyer's name, how are those transferred? Intercompany agreements. If it's a carve-out, what you mentioned a few minutes ago, maybe let me take a second and explain a carve-out. A carve-out typically is when you sell a part of your business or a part of a site you own. And so you could have two companies or more occupying a larger industrial site or a larger real property site or any type of space, physical or not. And so how are you going to share that particular site? Well, there's going to have to be intercompany agreements. And who's going to handle electricity for the site as a whole? Who's going to handle garbage disposal? Who's going to handle parking for your employees? This is where a lot of things fall through the cracks. The mundane issues of how to run a site day in, day out that now needs to service two companies and two sets of employees serving two different management teams. How are those issues going to be handled? Are there agreements in place to manage those relationships? And last, but certainly not least, regulatory issues. If you're selling to a strategic buyer, well, are there going to be antitrust concerns? Are there going to be concerns in terms of when they're doing due diligence, which I'm sure we'll talk about in a few minutes? Are they getting access to your commercially sensitive information? Are they getting access to your customer lists and other, highly sensitive information that if the deal goes sideways, compromises your competitive position? And national security issues. A lot of companies produce products that the United States government has an interest in, or other governments have an interest in. And do they want those products being sold or managed by an entity from another country that may be hostile to them? So you asked what the legal team has to look at to prepare for a divestiture. That's probably maybe 10%.
Okay. I want to get in this before we go through the rest of the process. So let's just make up a company and saying, hey, we're making up, you got same multinational corporation, bunch of business lines. And this is, and I want to even start with the strategy, because is that coming up in an annual review of our assets? Because I'm always curious, how do organizations conclude the carve out? Was it prompted by some external interest? Something of that. And then I want to get a sense of like, where do you come in? Is that anything, or is that just purely the business thinking like, oh, these guys want to buy it? Yeah, we can get something. Let's sign an LOI. Hey, Andrew, by the way, we just agreed to go sell this thing. When do you actually come in and help make sure that's going? What does that look like, just in that strategy part?
Sure, and it varies. So let me maybe describe best practices. Best practice is the strategy is front and center for every single action the business development team and the businesses take. I used to run political campaigns, and what I reminded myself and what I reminded my team is every day, if your actions aren't being taken to advance to get the candidate elected, your number one goal, then you shouldn't be taking those actions. So that checks everybody of, am I making this phone call to help the candidate get elected? Am I answering this email to help the candidate get elected? Am I developing this brochure to help the candidate get elected? What am I doing to advance that goal? And I've taken those lessons and applied that to my legal practice. And frankly, I think that's the best practice for a company as a whole. What is your strategy? What is your end goal? And in terms of business development, as you look at the different business lines, different regions of the world in which you do business, different activities, if all of them are not advancing your goals, then you should be taking a serious look at why are you doing that? Why are you expending company time and resources on activities, business lines, individuals, countries that don't advance your goal? And if the answer is you shouldn't be, then at that point you should be talking about divestiture or shutdown. So that to me is a best practice. When does legal get involved? Best practice from day one. Because when thinking about a divestiture, when thinking about all the strategic actions a company should take, there's a legal consequence to all of that. Whether you like it or not, lawyers have influence everything. And one needs to be cognizant of the legal ramifications of any action they take. And so, in my view, a best practice is to have the lawyer in the room when the strategy is being developed. A lawyer should be in the room when the business development team is entertaining different options, whether acquisition or divestiture, because I don't think I'm biased here. A lawyer can bring a lot of value to that discussion, not only through their legal expertise and experience, but through their approach to analyzing different issues and challenges.
Yeah, absolutely. A whole different view, thinking, and ultimately you're going to have to make all this come in the legal agreements.
Exactly right.
The more you understand, the better. Probably earlier at that too.
Yep.
So we got this company and we had our meeting. We decided it brought you involved, did the best practice.
Right.
Knows about it, has a good sense, already starting to think about scoping. Now, how does that work? Because what you described, and you gave me a good number of, we talked about change management, control provisions on customer contracts. You got the employee agreements, the tax, debt liabilities, permit licensing. A lot of the shared services you described, I think, would parallel over to TSAs, transition service agreements.
Yep.
And then regulatory. What you described sounds like you're going to need to get a number of other folks in the company involved through that. And yeah, how does that look like? How do you orchestrate that? And is there a certain sense of priority that cascades down, or are you trying to do all this at once?
No, you have to prioritize, and you have to be able to work with a team. No one person, especially when talking about a large multi-billion-dollar global company, is going to do it all by themselves. So you need to have a thoughtful, rigorous business development team and an active, rigorous, thoughtful legal team, finance team, HR, commercial, depending on the industry, environmental, IP. Intellectual property is huge. I don't care what industry you're in. You need to have a team in place that understand the issues and understand what they need to do. And frankly, you need to have a leader who can coordinate all of that. When looking at a large multi-billion-dollar transaction, between those who are working for the seller and those who may be working for them as an investment banker, outside counsel, 10, 20, 30, 40, 50 people beyond. And a strong project management leader is essential. Maybe I'll take a step back and discuss how all those different groups start gelling together and working. One, you get a team together representing all of those different stakeholders. But before you really can go to market, and as I said at the beginning of this discussion, with a divestiture, it's all about getting the work done right at the beginning. You want to put together a data room. And the data room is going to have all the contracts, all the licenses, all the permits, etc., that would be of interest to the buyer. Because the buyer's job is to do the diligence to make sure what it is bidding can be justified to its shareholders. And this is why the data room needs to be as thorough as possible and as easy to use. I have been involved much in my early days of practicing with some data rooms that looks like it was put together within 90 minutes, and it's sloppy, and there are agreements missing, and the folders are mislabeled, and the files say one thing, but it's another. Well, if you're trying to sell your house, you stage it, you present it well, you give the impression to the person buying your house that this is worth every penny and more what you're considering buying, where you think about paying for this house. That mentality should also apply to your virtual data room. If you're asking a buyer to bid 100,000, 100 million, a billion plus, you need to present that well. That is going to be a first impression for the buyer, like it or not, of how well your asset or business is run. And so if your data room is not organized properly, is not easy to use, what kind of impression are you giving? Think about how you sell a house. If you're staging a house to be as attractive as possible, same way as you stage a data room. Two other items that go to the buyer that make a first impression. The teaser. And so whether you are running the sales process or you've engaged an investment bank to run a sales process, it is typical to send out a teaser. A teaser is a 2 to 3 page document that basically says, look at this asset, look how great this asset is, how could you live another day without this asset? It tries to tease out all the potential buyers that may be interested in this particular asset or business. A potential buyer will look at the teaser and go, wow, I'm interested. They will express that interest to the investment bank or to the seller, depending on how the communication is, what communication is required. At that point, the potential buyer is asked to sign a non-disclosure agreement. They sign a non-disclosure agreement, and they subsequently receive what is called a CIM, a confidential information memorandum. And that's a confidential information memorandum is about 50 to 100 pages of details around the asset or business in question. It has financials. It has description of the org chart. It has a description of the assets. It's a thorough way of giving the potential buyer comfort in the asset it's looking to buy. Well, going back to that staging of a house, I've seen transactions where the CIM looks like it was put together by a bunch of folks over a 3-hour period, and I've also seen it where it's glossy and grammar is correct and the spelling is correct and the pictures are pretty. And this is another opportunity to present your best case why this asset should be sold for the price you want, and putting your best foot forward that this will be a professional, thorough, and efficient process. And once again, between the data room, the teaser, and the CIM, that's low-hanging fruit that a seller should get right to ensure all buyers in the process understand they're dealing with a professional outfit.
So we have this scoping stage. We have this clarify the strategy, then we're really scoping things and got a whole series of work to do to define this from those list of things we talked about. What you described is now more of a preparation, that we're actually building the assets that are going to be marketing materials for the business. In there, you referenced working with an investment bank. Can you walk me through when do you know it's time to get the bank involved? And even from a legal perspective, are you involved with that? You got to read the engagement letter and making sure we're not obligating ourselves to something screwy?
Absolutely. I think every company has different criteria of when they engage investment banks. If you really don't have a good feel for the parties that may be interested in the business or you're trying to sell, you may go to investment bank for their knowledge and for them to hold your hand throughout the process. You may also look to an investment bank if you're dealing with a very large transaction where their expertise would be invaluable to help you walk through the transaction. So every business has, I'll say, different criteria of when they tap into the investment banking community. Look, investment bankers know what they're doing. A lot of them are fantastic advisors, not only with getting the business or business sold, but in terms of the marketing materials you mentioned. They develop these marketing materials day in, day out. They know what appeals to potential buyers in different industries, in different business lines. So investment bankers, while very expensive, don't get me wrong, more often than not, you get your value out of them. And they're incredibly helpful in terms of the marketing materials I mentioned, and in terms of putting together a data room, putting together a confidential information memorandum, if done right, will likely take weeks, possibly months. And to have their guidance on how to package those materials where it appeals to the greatest amount of people and will inspire them to bid the highest amount is worth their weight in gold.
So anything on a legal perspective that you look at if you're reviewing multiple, and how does that work? Because you do a bake off, and you have the different investment banks come in, and they essentially always want to get to the end and get the projected price they're going to get for the business. But how does that work? I mean, are you sort of looking at terms side by side through that, or do they essentially get decide and then you get called in and yeah?
Well, going back to what I said, the legal team should be in the room day one. And so a best practice is the legal team is sitting in on all the pitches by the investment banks. And because in those pitches, the investment banks may promise certain things that if you engage with me, we'll give you X, Y, and Z. Well, you want to make sure whatever they promise or are presented can be found in the contract. There's also going to be commercial terms, what percentage they get of the deal. There's also going to probably be a tail where, let's say for whatever reason, you decide not to pursue the deal this month. Well, what if you pursue the deal 6 months from now? Does the investment bank get a piece of that action? And so most investment banking relationships have tails, whether it's 6, 12, 18 months, that if you sell the asset in question during that time period, regardless of whether they assist you at any point after you walk away from the transaction, they get a percentage. That protects their interests. And so what is heavily negotiated in any investment banking deal is the percentage they would get, their compensation for the deal, and the tail. Because what you don't want as a seller is a 24-month or a much longer tail where they may not be helping you at that point, but they still get a percentage of the deal. And let's say you aren't happy with that investment bank for whatever reason, and you've gone to another one. Now you're paying two. And if you're paying two investment banks, that's less money in your pocket. So you want to manage, you as the lawyer for the seller, you leave the commercial terms typically to your business development team, but your attention really has to be focused on the tail, confidentiality provisions, making sure that the appropriate firewalls are in place, especially as these investment bankers seek out others within your industry, and making sure whatever information you share, because let's be honest, they are going to be in meetings with your C-suite. They are going to have access to your confidential information, including pricing. What cannot happen is the relationship ends and they go to your competitor. So you need to have very robust confidentiality provisions in those investment banking agreements to ensure nothing adverse happens for either party.
What's the market for investment banking fees these days?
I'm going to give you the typical lawyer answer. It depends. You know what? Because we were talking before this call how incredibly busy 2021 was. Well, during that time period, investment bankers could exactly. Demand at much higher rates than maybe they could in 2008, 2009. So a lot of it, like any negotiation, a lot depends on where the market is at the time.
Okay, fair enough. We created the teaser sim, got the data room
Yep.
looking nice and organized. And what goes on from there? Because at this point, we're working the bank. They should either guide us on a targeted outreach approach or a broad auction, and they start floating around these teasers. When do you where do you keep eye on the ball and start kind of knowing when you need to get back on some of these things? And I'm sure there's some legal templates you're using along the way.
Absolutely. And I know I'm sounding like a broken record here, but best practice is I'm not jumping in and out. Legal is not jumping in and out of the process. Legal is there every step of the way. Once the management team decides we're going to pursue a sale, a best practice is weekly meetings where the different stakeholders report what is happening and what needs to happen over the next 30 days. So you're right. We've put together a data room. We've put together a teaser and the confidential information memorandum. So the teaser has gone out. Those who, with maybe the assistance of the investment bank, we've reached out to a broad swath of folks, strategic buyers, private equity. We have received interest from a variety of parties. They have signed the non-disclosure agreement, which if they have any objection to the non-NDA template we've sent out, those will be negotiated by the legal team. The NDA has been signed, and they have received the confidential information memorandum. With that confidential information memorandum will be a letter, and the letter will state, by X date, we expect your preliminary bid. And so it can be a range. It can be subject to further diligence. It can have all these caveats, and frankly, it will be non-binding. If someone is probably sending you a binding bid by that point, either you're in bilateral negotiations or it's a scam. Because in an auction process, let's be honest, at this point, they've seen your quote unquote marketing materials, but they're going to want more than that before they make a binding bid. And whether it's the NDA or the letter I've just described, all of that is drafted by legal, and a best practice will be to have those templates ready to go. You have received you've sent out that request, and the date has passed, the due date has passed. So now you have before you all of these potential bids. And it is now time to decide, the business development team, the management team, and the legal team, which potential bidders are going to be brought into the second round. What are you looking at? Well, you're going to be looking at price. You're going to be looking at liabilities. What liabilities do you think the bidder can assume? You're going to be looking at, does the bidder have the necessary capitalization to make this acquisition? Is the bidder someone with a strong reputation that you would feel comfortable sending your employees to work for? And overall, before any of those questions are asked, why are you doing the deal? What was your strategy? Remember, everything comes back to the strategy. If it's simply you need the money, then maybe there's a bias toward those bids that have the highest amount. If the driver of the deal is to just shed liabilities, who can assume these liabilities tomorrow and we have a clean exit? If the driver is to get our employees in a safe spot, who has a good reputation for taking care of employees, especially in acquisition? Your strategy drives every single step of the way. So you have looked at all your bids. You've measured those bids against your strategy, and now you've invited maybe 4 to 7 businesses, potential bidders, into your second round. The second round will involve access to your data room. It will involve management presentations. And going back to what I said earlier, prior preparation will have a profound impact on the success of your transaction. During all this reach out, during all this preparation for the sim and for the teaser, you also need to prepare a management presentation where key folks from the business line, or from the asset you're trying to sell will prepare descriptions for the potential bidders. And it may just simply be a script. They may offer Q&A, but here is your opportunity for the seller to once again demonstrate to the buyer, this is a business you want to buy, and this is a business that justifies top dollar. It is also a potential opportunity for the management team that may be going with the business to demonstrate their value. So management presentation, site visit, if you're buying a site, and possibly with that, a proposed purchase agreement. And so let me take a few moments to, one, talk about the data room that I mentioned at the beginning, and two, the purchase agreement. You have now spent 6 to 8 weeks preparing a data room that is staged and packaged well. Well, as you're preparing the data room, you also need to think about who will have access. If your bidders are strategic, more likely than not, they're your competitors. And you don't want them so early in the process to have access to your customer lists, your pricing schedule, your commercial T's and C's, when your contracts with your customers terminate, because that will give them an unfair competitive advantage. So if you are going to have strategic bidders in the process, one, you should segregate that information. So strategic buyers, so you can appropriately decide when to give strategic buyers that access. And two, the legal team should develop a clean team agreement. What's a clean team agreement? A clean team agreement compels the buyer to designate certain individuals within its organization or outside, maybe third-party consultants. And only those individuals will have access to the competitive sensitive information I just described. They will prepare a summary to aggregate that data and make sure that data is no longer competitively sensitive. And more often than not, they will show that summary to the seller. So the seller can also get comfortable that its competitively sensitive information is not going to the buyer. So that is a best practice in terms of setting up the data room. Let me talk about the purchase agreement for a few minutes, which is a huge lift for the legal team. As the process is going along, the seller, it is very common for the seller to develop the purchase agreement. And it is a decision of how seller friendly you want to make the agreement. And frankly, a lot of that is dictated by the market. Is the asset you're selling in high demand, or you are expecting a tremendous amount of interest? Well, if that's the case, make it as seller friendly as you want it. If the asset is something you're just desperate to get rid of, then probably a more neutral approach is the best. If I don't know the why, I can't develop the how. And this is where the legal team needs to work very closely with its business development team and the investment bank to decide how much of an interest will this asset or business generate, because that will dictate how the purchase agreement is crafted and what liabilities stay with the seller and what liabilities will go to the buyer. After the buyer has had access to the data room, the management presentation, the site visit, it's going to be asked to mark up the purchase agreement. As it's marking up the purchase agreement, the buyer is deciding which liabilities it wants to assume, which liabilities it doesn't, what indemnification rights the seller may have, what limitation of damages the seller may have, and really the ancillary agreements, like the transition services agreement, Clearly, this is where the interests of the buyer and seller diverge. The seller wants a clean exit. The seller wants the greatest amount of cash value and as short of indemnification rights as limited indemnification rights as possible, and in terms of compensation and in terms of how long they'll last. And of course, the seller wants a limitation on damages. The buyer wants the opposite. And so that's why it's important for the buyer to mark up the agreement. At a certain date after this, and so we'll call this round 2, the seller will receive the marked up purchase agreement and a bid letter. And really the marked up purchase agreement.
We're not an LOI. This is because we had, I'm thinking of the banking process that we would do an IOI to get down to the 4 to 6 and then have them submit an LOI, or in this case, which I'm curious because I've heard of processes where there is no exclusivity period and you run it through an end. And is that essentially what you're doing, is presenting your marked up PA?
So the process I'm describing is an auction process.
Okay.
Where you would receive the marked up purchase agreement and a bid letter. The bid letter could be, depending on what the process dictates and depending on the interests of the parties, this could be where you have that binding letter of intent. I commit to you that here is the markup. I will sign this. If you agree to this, seller, I will sign it tomorrow. I also have financing ready to go. I'm also committing to treat your employees a certain way. Since a markup typically involves negotiation, I've seen it both ways, where that's binding and non-binding. To your specific question on a binding letter of intent, where I've seen that most often used is we're in a bilateral negotiation, where you've gone through a lot of the steps I've mentioned, but it's only really only one other party, and you really have been throughout the entire process locking down the different issues, whether it's consideration, indemnification, liabilities, how employees will be treated, severance, etc. And in this bilateral negotiation, if you've been locking down these issues over time, at a certain point, the buyer will provide that binding letter of intent. Okay, it's time for me to fish or cut bait. And so here is my binding letter of intent. I am willing to do the following and be bound by this. At which point the seller will either accept or reject. In an auction process, you rarely see that binding letter of intent because you're really going step by step by step to narrow down the number of bidders until you get down to one. Once you get down to one, go back to what I just described about a bilateral relationship, you may get to that binding letter of intent. But in at least the phase I'm talking about right now throughout the auction process, you're not quite there yet.
And you could run a process where you don't have anything binding. You just run it all the way to a direct purchase.
Absolutely. And I've been
Which
part of that.
Which isn't fun for a buyer, I would imagine.
No. And once again, the market dictates a lot. If you have a very attractive business and asset, the seller has all the leverage in the world, and the seller can dictate this will be non-binding until I decide it is binding. And that gives the seller a tremendous advantage. One, they know how much interest this business or asset is generating. They understand where each party is landing in terms of consideration. Now, the market shifts overnight, and you may be in a situation where the asset or business in question, no one really wants. And therefore, the leverage is tipped toward the buyer. And I've seen situations where the buyer, in really phase one, when they get to teaser, I'm only interested in discussing this if I get exclusivity. Don't bother me if I'm not going to get exclusivity. And so I've seen it all. It all comes down to, like anything in life, who has the leverage and are they willing to exercise it?
Have you ever sent a time bomb offer?
Yes. And it's worked and it hasn't worked. But frankly, if you're the one sending that time bomb offer, you better be able to be prepared for the other person to call your bluff. Because I also have seen this where you send the time bomb offer, it's rejected, and then the other party goes, just kidding, can we continue the conversation? Now, clearly in that case, the leverage is tipped to the other side. So once again, you only make a threat if you're willing to act on that threat. Negotiation 101.
Thinking,
right?
It's just, in that situation, what do you do? So let's go back to, I'm selling a business and now I'm doing a carve out. What are the main differences when we're at this stage? We talked about TSAs, which I know is a big thing. There's a lot of these little ongoing things we're going to have to deal with that we need to document and really lay that out. Besides TSAs, which we can definitely unpack here, is there anything else?
Yeah, I mean, the TSA reflects a broader question when dealing with carve-out versus divestiture. A divestiture, and goes back to the strategy, you're looking to walk away, have a clean exit. And so your pressure points in a divestiture is to get the most amount of consideration and to limit your liability across the board. Those come into play in a carve-out as well. But in a carve-out, you're still living with the person, especially if you're carving out an industrial or other type of site. You're still going through the same gate as the buyer. Your employees may still be grabbing lunch with the buyer. You're still going to have to work with them on issues that impact the site, whether it's garbage disposal, parking, traffic issues, community service events. It runs the gamut. And so your ability to be as aggressive in a carve-out, I would say, is not as great as it is with a divestiture, because you're still living with the other party. And as importantly, whether it's TSA or other ancillary agreements, have you thought about all the issues I've mentioned? How two separate businesses are going to operate and work together within the same geography. And the legal team with the business and the operation and the commercial teams need to sit down and go through every single scenario, because that is where things fall through the cracks. And if one of those carve-out agreements, those intercompany agreements that will help govern the site, are forgotten, then whoever has the leverage post carve-out is going to use that leverage. The best time to address all the menu of issues I've shared with you today is during the negotiation of the carve-out itself. You never want to kick the can on the ancillary agreements, because I've seen more often than not that comes back to bite you. And because the leverage shifts after the deal is done.
So when do you start? Because you're drafting the TSAs.
The legal team is absolutely drafting the legal team is drafting the purchase agreement and the TSA. So in terms of the process letters I've mentioned, you may also put, besides this markup of this purchase agreement, please tell us what employees, how you're going to manage our employees that may transfer, and please share what transition services you may want. In addition, with the purchase agreement, I may send over a suite of ancillary agreements that address not only transition services, but trash, easements, real estate, operation, permit, and other issues. With a carve-out, to be quite candid, the purchase agreement is the least of my concerns. Because the purchase agreement, I and every lawyer in town has a template for the purchase agreement. And you can refine that as much as needed for any particular deal. Where a lawyer brings the most amount of value in a carve-out is thinking about those ancillary agreements, bringing to bear their expertise and experience of, what about this? What about that? How are we going to manage this? Well, if the other party now has control of the entry and exit, how do our employees get in and out? Some of the most mundane, pedestrian stuff you can think of. But if it's not done right, you will see more value erode from the deal than you could possibly imagine if those ancillary agreements are not done properly and thoughtfully. So in my personal view, a good lawyer will be focused on those ancillary arrangements and agreements from day one, because that's in a carve-out, that's where the value lies.
There's not a lot of templates for those. You said most of them you got to draw from scratch?
No, there are templates, but you think about it with a purchase agreement, you know indemnification, warranty, purchase price. Any decent lawyer can go through the sections of a standard purchase agreement, but a services agreement are particular to the services at that site. A transition services agreement will be particular to those services you're willing to provide post close, and the buyer is willing and eager to pay for post close. So that requires far more work and far more teamwork, because as the lawyer, I'm not at that site day in, day out. I'm going to have to reach out to those folks who are, to share with me what services, what dials need to be turned, what items need to be thought of that will help that are essential to run that site. And frankly, as the lawyer, I'm not in a position to know that. I will depend on them to let me know.
When you're reviewing this with buyers, and I'm trying to imagine them, like, do they see this somewhere in the sim where here's an itemization of TSAs that are likely going to be part of this deal?
Yeah, you will more likely not have it in the sim. Now, here's a fundamental difference between your strategic and your financial buyers. Your strategics, which are more likely than not in the same industry as you, run the same types of sites as you, they know what to ask for. If you're missing something, they'll go, what about this? What about that? How are we going to handle this? And if they forget to ask, they probably have folks already on the payroll that know how to do all of that stuff. So your financial buyers are going to be far more dependent on a TSA and far more dependent on you as a seller to think about all these ancillary agreements, because it is highly likely that your strategic buyers understand the issues involved and understand the responsibilities they will have to take on day one over your financial buyers who are just looking at it as an investment and may have zero experience when it comes to running and operating the site that is the site or business being sold.
What are some do's and don'ts of TSAs?
Well, as a seller, you want to provide as few services as possible and for as short amount of time as possible. It all goes to your strategy. If you're more likely than not, your strategy is, I want a clean exit. So you want no TSA if possible, and if a TSA is required, as short as possible. Goes back to what I said earlier. What's your strategy? Your strategic may or may not be the highest bidder, but if it gets you a clean exit and that's your end goal, you may sacrifice some of the consideration to effectuate your strategy. Your financial buyer, over your strategic, will probably want a longer term and more services, because their learning curve is much steeper and they are going to have to get up to speed on what it takes to run that business or site. Moreover, with drafting any TSA, the mantra I repeat over and over again to anyone on the team who's helping me: no good deed goes unpunished. And so you may need to do a TSA to get the deal done, but you should be charging an appropriate amount. The TSA should not be a giveaway to get the deal done. I talked a few minutes ago how ancillary agreements can erode value. Those TSAs, if you're dedicating a tremendous amount of your resources, licenses, and people to managing the TSA relationship and not getting compensated, you're losing money every minute of every day that TSA goes on. So remember, the TSA should be for fair value or a markup, frankly, because you are providing a service. And the TSA should also contemplate your goal. If it's a clean exit is your primary goal, then as short and sweet as possible.
There's a whole topic we can talk about the dollar company for sale, and everything's all through the TSAs and what you're actually getting.
Exactly. But it all comes down to why are you doing the deal? And that should govern how you package your marketing materials, how you package your data room, how you package and draft your agreements, including the purchase agreement and including the TSA and other ancillary agreements. Everything is dictated by the strategy.
I'll throw one more in more before we get close to the end here.
Right.
Let's talk about the difference between purchase agreement of an acquisition versus a carve-out. Are there any distinct differences there?
I think I've maybe touched on those a few minutes ago, that in terms of what the seller wants in a carve-out, in a divestiture, you want the clean exit. With a carve-out, you have those ancillary agreements. And so your ability to be aggressive is muted. But as the purchaser, you also have different interests in a carve-out. You want those. You do not want value being eroded through those ancillary agreements as well, because you have decided, looking at that asset or business in question, it is worth X amount of dollars. You have paid that amount. But if you are now paying a premium via those intercompany agreements or via the TSA, then how you justify that deal to your shareholders is slowly creeping away. So the focus, and I've seen this forgotten more often than I can count, the focus in a carve-out, whether you're the purchaser or the seller, really needs to be those ancillary agreements. Because the purchase agreement, don't get me wrong, is very important, but once a dollar number is established, the consideration for the asset or business in question is established, yeah, you're going to negotiate indemnification. Yeah, you're going to negotiate liabilities. But where your value can increase and decrease after close and for a 2, 3, 4, 10, 20-year time period are those ancillary agreements. So they need to be done right, and they need to get the attention they deserve.
Andrew, what's the craziest thing you've seen in M&A?
Where everyone forgets why we're doing the deal in the first place. Deal fever. Deal fever is a very deadly thing and very costly thing. And we probably could do an entire discussion on some of the worst deals ever. Thankfully, I've not been part of those because they've been ranked, and no company I've ever been associated with is listed on that. But you start off with Time Warner and AOL, and you can go down the list, and you forget why you're doing the deal. You forget how much the asset is worth, and you let your ego get in the way. And I've seen all three occur, and it's never good for the shareholder.
You've never seen it in person on a deal. You've seen it from the sidelines.
Thankfully, I have. I've been very fortunate to work with some top-notch teams.
I wanted a story, but that's so true. Like you wonder when there's so many of those classic examples that you read about that anybody can reference, even books I've worked on, we've referenced, but it's so true. But there's have you seen any studies around that?
I think Harvard Business Review has done some. I mean, the AOL Time Warner deal has been examined over and over again. You look at GE and their acquisitions over the years, which in retrospect and even in real time, it made no sense that they've had to unwind. Look, there's a very sad history of companies pursuing transactions that did not advance their strategy. And over time, it eroded shareholder value. Over time, it had a horrible impact on employees through bankruptcy or other events. And, you just come down to, why are we doing the deal? Are we paying the right price? Are we selling it for the right price if you're on the other side? And are we checking ourselves and checking our egos at the door? And one of the things I always encourage is a strategy moment. Before any discussion around any transaction, let's remind ourselves, why are we doing this? And is the discussion we're about to have and the decisions we're about to make, do those advance this strategy? Going back to the campaign I mentioned a few minutes ago, my job is to elect that candidate. My job is to advance the strategy of the company. If I'm taking any action that goes against those two goals, I'm doing the wrong thing.
Thanks for bringing such a great theme to this podcast.
Thanks. I've enjoyed it.
Yeah, the marketing's going to love working with it. Those of you listening, if you know anyone that's been a victim of deal fever and would like to share their experience, because we always want to learn. We always want to take lessons learned, and that's what M&A Science is all about, learning from experience. But if you know anybody that would be open just to sharing, I think it'd be great just to us to learn a little bit more about what are the cause and effects and how to treat it.
Absolutely. No, unfortunately, it's a common ailment that that good management teams and good lawyers try to squash.
We'll create an initiative. We'll build a cure, treatment for it.
Build a cure, exactly.
Andrew, thank you so much for your time. I enjoyed this conversation and learned a lot.
Appreciate it. Thank you again.
Till next time, here's to the deal.